and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the nation. Let's take a look at the headlines. Review petition filed in Supreme Court challenging the same-sex marriage judgment. Supreme Court refuses to issue notice on Tamil Nadu government's plea, challenging High Court order in RSS Route March case. CJI expresses concern over increasing adjournment requests by lawyers, says the top court cannot become a court of adjournments. Supreme Court collegium recommends names for appointment of Chief Justices to 3 High Courts. Scientific survey of Gyanvapi Mosque complete. ASI informs Varanasi court while seeking date to submit report. Union government allows direct overseas listing of Indian companies. Now let's take a detailed look on the headlines. A review petition has been filed before the Supreme Court, challenging its October 17th verdict, which refused legal recognition to same-sex marriages. The same-sex marriage case was heard and decided by a 5-judge constitution bench of the Apex Court, comprising the Chief Justice of India D.Y. Chandrachud, along with Justice S.K. Kaul, Justice S. Ravindra Bhatt, Justice Hima Kohli and Justice P.S. Narasimha. 4 of the petitioners have now moved the Apex Court challenging this judgment, contending that the Supreme Court of India neglected its constitutional duty to protect the fundamental rights of the citizens by discriminating against queer Indians. The petition further says that the Supreme Court essentially dismissed the concerns of the LGBTQIA+ community with mere well wishes for the future. The plea claims that the majority judgment compels young queer Indians to conceal their identities and live inauthentic lives if they wish to experience the joys of a genuine family. The plea also challenged the judgment on the grounds that the top court erred in declaring that there is a fundamental right to marry, that the court refused to grant adoption rights to queer couples. It also highlighted that the Supreme Court's majority opinion, though acknowledges that queer persons have a right to be in a relationship by virtue of Article 21 of the Constitution, it does not impose any requirement on the state to officially recognize such relationships or grant the rights associated with being in a relationship. A 2-judge bench of the Supreme Court, comprising Justice Suryakant and Justice Dipankar Datta, refused to issue notices on 2 special leave petitions filed by the Tamil Nadu government against the order of the Madras High Court granting permission to the Rashtriya Swayamsevak Sangh to conduct route marches in all the locations requested by it. The case in question underscores the legal complexities in striking the balance between fundamental right and maintenance of public order and security, a common issue in democratic societies. The present case pertains to a legal dispute between the state of Tamil Nadu and RSS. The state government refused permission to RSS to conduct route marches, citing concerns related to disruption of law and order and risk of communal violence. However, the Madurai bench of the High Court of Madras subsequently issued an order instructing the state to allow RSS to conduct route marches, stating that the reasons cited by the state government were inadequate. The state government contended that it took into account the history of such marches leading to communal clashes, referencing the violent incidents that took place in West Bengal and Haryana recently. It refused permission to conduct route marches despite the order of the High Court. The High Court, in consequence, issued a notice in a contempt petition filed by RSS against the Tamil Nadu government on October 18 this year, calling the reasons cited by the state government lame. In response, the present SLP was filed before the top court. The top court quizzed the state government if an intra-court appeal is not available in the court. The bench questioned if the single judge has committed an error, there is a forum available in the High Court itself. Can the division bench not correct the error of the single bench? Senior advocate Kapil Sibal is appearing for the state government, while RSS is being represented by senior advocates Guru Krishna Kumar and Madhvi Diwan. The top court has adjourned the matter till November 6th, requesting the state government to produce documents to show the SLPs filed by it are maintainable or not. While highlighting the large number of adjournments sought by lawyers appearing before the Supreme Court, the Chief Justice of India D.Y. Chandrachud said the Supreme Court cannot be allowed to become a Tariq pe Tariq court, meaning a court of adjournments. The CJI highlighted that from September to October, during the span of this 1 month, over 3,600 adjournments were sought by lawyers. The CJI expressed his concerns how the increasing trend of adjournments affects the justice delivery system by defeating the purpose of expediting cases. The CJI said that this defeats the trust of the citizens and thus this is a moral responsibility. The three-member collegium of the Supreme Court, headed by the Chief Justice of India D.Y. Chandrachud and also comprising Justice Sanjay Kishan Kaul and Justice Sanjeev Khanna, have recommended the names of Justice Ritu Bahari, Justice Chakradhari Sharan Singh and Justice S. Vaidyanath for appointment as Chief Justices of the High Courts of Uttarakhand, Odisha and Meghalaya respectively. Justice Bahari presently presides at the Punjab and Haryana High Court and is proposed to be appointed as the Chief Justice of the Uttarakhand High Court, pursuant to a vacancy arising after Justice Vipin Sanghi's retirement as the Chief Justice of the High Court on October 26 this year. On the other hand, Justice Singh is a judge at the High Court of Patna and his name is proposed for being appointed as the Chief Justice of Odisha High Court, as the current Chief Justice Subhashish Talapatra retired on October 3rd this year, and Justice Vaidyanath is currently serving as a judge of the Madras High Court. And in the resolution recommending his name as the Chief Justice of Meghalaya High Court, the collegium took into consideration that Justice Vaidyanath has acquired considerable experience while dispensing justice in one of the largest high courts in the country. The Archaeological Survey of India has informed the Varanasi court that it has completed the scientific survey of the Gyanvapi Mosque complex, while being granted additional time by the court to compile and submit its report by November 17th, despite the original deadline to submit the report being November 6th. In retrospect, the ASI began its survey at the mosque complex after the Allahabad High Court made an order stating that the survey was necessary in the interest of justice and beneficial for both Hindu and Muslim parties involved. During the survey, the Anjuman Intizamiya Mosque Management Committee, responsible for the management of Gyanvapi, raised many objections. It was alleged that the manner in which the survey was being conducted by the ASI could lead the structure to collapse. The committee also approached the Supreme Court against the order of the High Court. The Apex Court, however, did not rule in favor of the Mosque Management Committee. But it did, in its order, prohibited any invasive actions during the survey, ruling out excavations unless deemed necessary. The survey aimed to determine whether the 17th century Gyanvapi Mosque was built on the site of a pre-existing Hindu temple. The Union Government of India, in a significant move, has permitted Indian companies to list on foreign exchanges as well as in the International Financial Service Center, although the same shall be done subject to certain conditions. This development will help the Indian companies to gain access to global capital and a better valuation. It also necessitates adherence to government norms in the specified foreign jurisdictions. The government has amended the relevant provisions of the Companies Act to allow Indian companies to list their shares in specific foreign jurisdictions. To facilitate this, the government will also require to make changes in other regulations, like the Foreign Exchange Management Act. Currently, overseas listings by entities is carried out through the American and global depository receipts. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.